Hi everyone, and welcome to our first MCN webinar for 2018 with the Data and Insights Special Interest Group. My name is Angie Judge and I'm here with Elena Jedwabska, and I'm also here with our special guest, Paulina Jedwabska, who is the Head of Information Governance and Departmental Records Officer from the Department of Digital, Culture, Media and Sport in London. And Paulina is a special guest from us in the museum industry because she used to work at the National Portrait Gallery up until recently. And today we're going to talk about the GDPR and privacy regulations that are coming in for the EU in May, but that also affect lots of other museums from around the world. So with that, I will hand over to Paulina.
Hi everyone. Yes, GDPR is fast approaching, and we are going to talk about what it actually means to you guys in the museum sector. So what you need to know about GDPR and what it actually represents and why everyone is so excited about it. We should be excited about it as individuals because what this regulation brings to the table is accountability, trust, and reassurance that we are getting from the people who process our personal data, that they are doing it in a safe, secure, and transparent manner. And for us as data controllers, it means that we are getting more accountability over how we process personal data, what we can and can't do with information that public and our employee give us. So I'm going to share those slides with you, and I hope that Angie can share them. So you can either focus on what I'm saying or in addition read to what is on the slides. So we know why we're doing this, because there is more technology involved, there is a greater need for transparency, but what it actually means and how it actually affects us. So the EU applied to, the GDPR applied to European citizens, but it's not just to say, it's not just simple to say every European citizen will be covered and that's it. If you process personal data within EU, you are obviously going to rely on this new regulation. However, if your museum or gallery or event is based in another country outside of EU and you're targeting specifically European citizens, then by all means, that means that GDPR will be applicable. And this also means that if you have a museum in America or in New Zealand and you are actively providing services to European citizens, then you have to look at how you comply with this regulation and how you protect information of the European citizens to ensure that you follow the rules. It also means that there are some exemptions. For example, if you are processing information for domestic purposes. From museum perspective, it's unlikely because you're a business and you want to ensure that greater public visit your attraction and donate to your cause. But there are other legislation that you should also consider. So GDPR is this big wow, an amazing factor that is being published, and there is a lot of information about it at the moment. There is big buzz, but that's not it. And I would like to strongly encourage you to think about other legislation that may also affect your work. So what you need to know from day one, you have to be able to prove, you have to be able to evidence what is your legal basis for processing, which means you need to know that you have gained consent, and consent has to be freely given, unambiguous, informed, with options to be withdrawn at any point. And you need to be able to prove that you seek that consent at the time where data was collected. Your other option is contractual obligations, where you either have a contract in place or you are taking steps to enter the contract. So that potentially can mean, to the museum sector, your yearly subscriptions. If someone has your membership card, that's a contractual obligations where you provide a service by letting the public enter your institutions, and in return you process personal data by providing them with a card with their names and contact details, for example. You also have legal obligations where you are forced by law to process personal data, and that, for example, would be taxation. Gift aid is another example where you are bound by the law to process personal data. Vital interest very rarely would apply to museum sector. It's a life or death situation, so I really hope it won't happen to any of you. But what you can think about here would be the emergency service when they're trying to contact next of kin because there has been an accident. Public task. This is the tricky one. You can process, hold, and store personal data because it is in the greater interest of the public. You have to remember that there is a difference between PSI, public sector information, and the public task. Those are separate, at least in UK. And you have to be able to define how you concluded the decision that the processing that you do is within the public task. And last but not least is legitimate interest. This is where organizations process personal data because it is in their interest. And massive caveat here, what you have to understand is that public interest from May 25th will be removed from public sector institutions. GDPR only allows private sector to rely on legitimate interest. Saying that, in UK there is equivalent of the GDPR being processed by our parliament at the moment. There is a debate, and current discussion is at the state where legitimate interest can be used by public sector. However, it cannot be used as at the same time as public task. So you can rely either on legitimate interest or on the public task, but you can't rely on both of them at the same time. Data protection principles. This is really important. So for all of you who are a small organization, for all of you who have limited resources, this is a crucial message for you. From May 25th, what you have to be able to do is being able to evidence that you follow those 6 principles. It used to be 8, it's now 6, they've been consolidated, and at the heart of this is accountability. You as organization processing personal data are accountable to the individuals, to the people whose data you are processing. So think about what this means in your context. So purpose limitation. This is about thinking what was the original reason why you collected information. How did you decide what's the minimum, what's the maximum of information needed for that specific purpose, and ensuring that you're not collecting additional information if it's not required. Data minimization is the next step to it. It's ensuring that you keep information that is required for that particular purpose. It also means that when you no longer need that information, you let it go. You ensure that you have right retention schedule that can state how long you're going to hold on to information for various reasons, and at which point you are going to delete them or destroy them if they're paper copies. You need to make sure that data is accurate. So giving people right to contact you and update their information, making sure that the information that you store are adequate, that they are accurate, that they are what they meant to be. So if someone has changed address or become an adult and so on, your database reflects that, and you have capabilities of updating those information. Storage limitation. Everyone is thinking that cloud is free and is unlimited, but that is not true. Do not think that. You have to think about both paper copies and digital records. What you have to understand is that you shouldn't keep information forever and ever, because I might have a use, or I might be able to utilize that information later. If you collected information for a specific purpose and that purpose expired, you should let things go, and this is where storage limitation come into force. Don't keep information for longer than necessary. And this goes with integrity and confidentiality. You as service providers to the public, you are obliged to ensure that the way you process personal data is done in a correct way, that we are accountable and we as public have trust. And by doing this, you follow the principles and legal basis. So again, going back to previous slide, understanding your legal basis, making sure it's fair and it's transparent, so your privacy notice come into force, and this is giving public better chance of understanding what you are doing with the information, what they can do to stop, edit, and change, and making sure that it's all secure and in good manner. So we are all loving consent as individual, that is, from your employee, public, even private point of view. Consent would be the least favorite options, simply because it can be withdrawn at any point. And therefore, you have to be able to think, what are the implications if someone withdraw consent, and what are the other legal bases that you can fall on. So what actually consent mean to us? You have to be able to demonstrate that you gain this consent, but also for special categories of data, you need explicit consent, and special categories of data would be anything that you can discriminate against. So think about political view, racial origin, ethnicity, sexual orientation, health information. Those kind of data, if you store, process, or hold them, will require explicit consent. And this also means that you should really consider that from HR point of view. When you employ people and you have that one anonymized page where you don't put your contact details, but you put your race, gender, ethnicity, age group, and so on, ask explicitly for consent, because from May it will be required. You also have to remember that from May there is going to be a change on the consent for the kids. Currently in UK, the age for parental consent is 18. What you have to remember is that from May, it is going to be reduced, and different countries do have rights to establish their own parental age within the limits, and GDPR set those between 13 and 16. So you have to think about your processes, how they are going to reflect the change that your 12, 13, 14, 15, 16 years old can be affected. In UK, in the UK version of the bill, we're going to have consent age set up at 13, 1-3, which will prove really difficult, because kids at that age do not have ID cards. And what is going to be a tricky part is how you determine what is proportionate way of checking and assessing that someone is at the age of 12 and not 13, for example. So something to consider, and how you're going to evidence that. So again, going back to the previous slides and the principles. What you have to know about profiling and right to object. So we all in the museum sector want to ensure that the biggest amount of public go into your institutions, to your events, to your exhibitions, and therefore you are targeting people based on their behavior, their previous visits, their activities, their location, and so on. So profiling would be automated processing, but also targeting people based on their activity or based on their preferences. You don't need consent to profile people. However, once you get to a stage where you get the pool of people that you want to target, you must consider what legal basis you are going to follow. You also have to put processes in place to ensure that you have robust infrastructure to stop processing and stop profiling once the data subject, the individual state, I'm not happy, please stop. So this is something that you have to be able to document how you're going to do this, and you also should consider, and this is advice, this is not a legal statement you have to, but I would strongly encourage you to look at privacy impact assessment, which is a risk assessment. It looks at your process, so what's your activity. It looks at your risks associated with that process. It looks at your mitigations. And at the end, you come to a conclusion whether this process is safe to go forward, or should you look at other mitigations. And for that reason, I would strongly encourage every single one of you to consider privacy impact assessment, or DPIA, and how is that fitting with your profiling. Okay, so we as individuals getting enhanced rights. So what are they? Rights to notice. This is where you put individual in the first place and notify them about how you do process personal data, how you store it, who do you share it with. So easy way to address that would be a privacy notice, where you put it on your website. Wherever you collect information, you can get this up to date. Privacy notice can contain information about different aspects of processing. It can also be linked and merged with cookie policy. Cookies are not going away just yet. I think they will eventually, because technology is moving on. And my prediction is that within the next 5 to 10 years, cookies will be the thing of the past. But currently, they do apply, and you do have to inform people about what cookies you are installing, why, and so on. This is not part of GDPR. Cookies is regulated by PECA, which is the Privacy and Electronic Communication Regulation that is already in place. So as I said at the beginning, think also about other regulations. So going back to the rights of individuals, access. You need to be able to provide people with the access to their data. That means either having an interface on your database, on your CRM, where people can see what information you store about them, or being able to do exports, which is the big data portability, where you collate all the information and send it out either via email or FTP site, whichever is secure. Right to erasure. This is really tricky because you have to remember a few things. You have to follow the legal obligation. If you collected gift aids, for example, you are bound by the law to keep information for 6 years from accounting point of view. Therefore, people can't just say, oh, I would like you to delete my information, and therefore you are automatically bound to press that delete button. You have to understand what information you have, what are the other than GDPR legal basis for you to keep this information, then ensure a process where you can respond to subject access requests and say, yes, we are going to delete this. No, we are going to put you to delete most of your information, but keep some of them and put you on the suppression list. Or no, we actually can't do this for another 3 years, or whatever the period might be. And that also goes to rectification. So when people have their information stored on your database, they need to be able to either contact you or being able themselves to edit and update that information. And again, you need to think about the process. How is that going to work? What interface you're going to provide to the public? And that also goes to your employees, how people within your organization can ensure that their information are up to date. And last but not least, right to object to the processing. So what are you going to do when people withdraw their consent, or when they are unsubscribing en masse from your emails and newsletters? So think about user interface in your relationship with the public. Engage your IT and security, but also think about user experience, because what you don't want to do is alienate people. You want to make sure that they are coming back to your site and therefore to your museum and so on. User interface isn't just about electronic communication, it's also about ensuring your first point of contact, your telephone center, your VSA security on site are also aware of those requirements and how to communicate the right thing to the public. So here is the tricky part. We are data controller. We are the people who decide how data is stored, processed, held, assimilated, disseminated, and so on. So you decide what is going to happen. What are your purposes? What are your minimum of data that you need to keep? How long you should keep it? This is what data controllers are all about. You decide what is going to happen. But with this in mind, you are going to need people to do it for you, i.e. your third-party service providers and suppliers. When you select a processor, the supplier, the service provider, you have to think about the legal basis and the principles. So think about security, think about cyber essential, think about their ethics. Look what happened with Facebook recently. How is that going to give you as data controller and the public assurance that what you're doing is the right thing and how they are doing it on your behalf is correct. You also have to consider the data breaches and the responsibility around it. Your supplier will have to notify you because both parties from May are going to be liable. Currently, only data controller is liable. So ensure that your contracts, your commercial aspiration, and therefore invitation to tender, your terms and conditions, your purchase orders, and so on, do reflect those changes on both controllers and processors, clearly spelling out who is who, which are responsibility of each party, and what are the liabilities. And that's it from me. I believe that you have some questions for me, so I'll be happy to answer, or at least try to provide a best answer as I can.
Well, thank you, Paulina. That was absolutely fantastic. And I have to say, there's so much hype on social media about GDPR at the moment, and it was really wonderful to get a really practical guide to what it all means and have that in museum terms as well. So thank you very much. And I think to me, as an individual, it sounds like a lot of these things that are coming with GDPR make a lot of sense, and they seem like really reasonable things that we should all be doing in the first place, right?
Exactly. It is. I mean, if you think about it, the previous regulation was in place, you know, for over 10, 15 years, and therefore technology has changed. We as consumer have different aspect and attention to what is our data and how people are treating it, and you know, it's about making sure that it's a two-way conversation. We provide you with the data, you provide us with security and trust that what you're going to do with my data is secure and you're going to use it for the right reason. So yes, I think it's about time.
And Elena, I know we had lots of questions coming in from our Data and Insight SIG members. Do you have a couple there we can ask?
Yeah, I think you cover some of them, but probably some tips and recommendations will be very useful. So for example, you mentioned these 6 principles and to follow. And so if you're a museum, as you mentioned, with a small museum with limited resources, what will be your recommendations in terms of priorities, like the main task they need to accomplish?
So a couple of things that I probably should have said earlier is you need to understand what data you have and where you have it. So starting with data mapping exercise, asking your different teams, your finance, commercial, learning, curators, exhibition, IT, security, and so on, to map their processes, tell you what is that they're actually doing with personal data, and understanding what is that they're using for that particular purpose would be step 1. Then assign someone who will have data protection officer role, and I know it's tricky because you know small organizations have limited resources, and GDPR puts you in a difficult positions because you need to ensure that DPO doesn't have conflict of interest, have direct reporting to senior executive level and so on, but also is independent and at the same time have unlimited resources. And you know how you justify that is tricky, but I would strongly encourage you to put a dedicated person on the GDPR, because as I said at the beginning, it's not just GDPR. Everyone is hyped and very excited about it now, but I reckon within the next 2, maybe 3 years, we're going to see PECA, the Privacy and Electronic Communication Directive, revised. There is already discussion at European level on what should be included. This is the directive that looks at your electronic communication, so all your emails, your campaigns, your cookies. It's not just one-off activity with GDPR and DPO to address that. So do your data mapping, appoint someone who can oversee it, and then look at your processes, look at your supply chain. So who share your data, where do you keep it, how they protect it, how they can edit, how public can edit it, and also what Information Commissioner in UK is saying is they won't be fining people on day one. Lucky us, in UK, it's going to be bank holiday, so we've checked, ICO is going to have Monday off, but that doesn't give you extra day or weekend to hide your breaches. Think about what needs to happen, and this is the crucial message that ICO is trying to promote, is they expect that people won't be fully compliant. If you look at GDPR, there are so many requirements that are impossible to implement in such a short period of time. So what ICO is saying is, as long as you can evidence that you've addressed your major risk, you had risk assessment done, you look at your risk, you addressed them, you then created an action plan, you've started implementing the action plan, and you still have a plan to go forward towards your compliance, you're good to go. Mm-hmm. On the 25th of May, if you can evidence that, you won't be fined. Mm-hmm. Unless you have a breach, which I hope won't happen to you.
Yeah, and this is actually, I mean, the interest in this group I'm seeing is that this is a law basically that affects everyone in the world, not only museums in the UK or in Europe, but also museums around the world that have data from Europeans. So yes. Yeah, you can talk a bit more about that.
Sure. So GDPR applies to European citizens. It applies to processing of data in Europe. So if we have, for example, European citizen, and we have a museum in New York, for example, that is actively targeting European citizen to visit them, to purchase their fantastic goods and visit their website, then they are bound by the GDPR because they're processing my European citizen data. Does that help?
Yeah, that helps a lot. And we have an audience as well that is very interested in all the digital related interactions, so email, website, social media. Any specific advice for those like digital touch points with customers, with users?
Yes, so a couple of things. First of all, focus on GDPR, but also go back and Google PECA, the Privacy and Electronic Communication Regulation, because this is what goes really into heart of your email communication, your newsletters, your digital and social media campaigns, not the GDPR, but the PECA, and eventually they will tie in together. They're meant to be released at the same time, but they're not. So what you have to think about is your privacy notice. When you collect information, you have to be able to provide your audience with that. And my advice and recommendation is to make sure that it's collapsible, it's layered information. So you have taglines, you have short, brief info, what this paragraph is about. And if people want to know more, then they click and have extended version. So that way you don't end up with 840 pages of font 2 super long notice, but you can dip in and out of information that is useful and practical. That goes kind of with cookies, you have to be able to provide people with the information on what cookies you are installing, why you're doing this, and how they can opt out.
And actually, my last question was that I had in my list is around cookies. Yeah, if you provide all that information to users, of course, they are more likely to opt out, and that they currently are, and that may affect like data collection. So, for example, tools such as Google Analytics rely on cookies to collect users' data and their behavior. So you predicted some things about cookies and how may disappear in the future. What do you think will happen as well with digital analytics tools in that sense?
I think the technology will move on, and we will develop other systems to monitor and target people. So the profiling will move away from the spy tools installed on your browsers and how you where you click. I think technology will move on to do it in a slightly different and more transparent way. But I don't think it will go away completely. So yes, we will lose cookies that are installed on your computer and monitor your browsing activities. I think that that's going to happen within the next 5 to 10 years. But what will happen in parallel to that is the new technology will emerge that will be more transparent and more open about how that data is collected, and that goes back to the profiling, ensuring that we can profile people, but people are aware of how this is happening and how they can object to it. But I'm not IT geek, so maybe this is my wishful thinking.
Thank you so much for the presentation and the responses to all the questions.
My pleasure.
So, Angie, do you have any final thoughts, questions?
And just to note that, oh, sorry, Paulina.
So I was just going to say that I wish you all the very best, and I hope that none of you will have to deal with breach. You're all going to have wonderful approach to personal data, and all the public will fly through to your websites and your events and your exhibitions.
Well, after that introduction to GDPR, I'm sure we're all much better equipped than we were yesterday. And so thank you so much. Thank you, Elena, for hosting us. And to those that are tuning in, our MCN Data and Insights SIG will be releasing more webinars shortly. Upcoming, we have split testing and data visualization, so stay tuned.
Thanks.
Thank you.